Heather Hansen, and we are taking a break in the final parts of the Adam Matos trial. The defense just gave a closing, really just calling upon the better angels of the juror's nature, in his words, to spare Adam Matos's life. I think that that was probably a very grasping at a very small straw, but I want to bring in my fellow host here, Aaron Keller. I'm so glad to have you here to talk about this, Aaron. What did you think about that closing?
Well, look, when your client's life is on the line, you can pretty much say whatever you want to try to appeal to the jurors' sympathies, the better angels of their nature, whatever you want to call it, to try to pick life in prison. And again, in Florida, all they need is one to say, I don't think this is a death penalty case. If the jury splits, it becomes life in prison. It's got to be unanimous if the jury wants to go to the death penalty. And that's a high burden for the state to meet. In this case, though, look, you've got a jury that deliberated for 2.5 hours, went on the top charge for every single one of the deaths, even though there was a little bit of discussion here about whether some of the murders should have been second degree or something lower down the chain. The defendant didn't help himself by testifying, in my opinion. In this case, I think it hurt him. So look, the closings, trying to put the best whitewash possible on a horrific set of circumstances, but whitewash doesn't cover everything. And the jurors are going to be thinking about that back in the room.
Yeah, I don't even know that he was able to do any good whitewashing, but I do want to point out what some of the viewers said. Smiley and Pink Slippers all talked about the idea that him speaking to Jesus and Shakespeare may have actually offended some people. You know, you do have to be careful when you start talking about people's religious convictions and religious beliefs, because you could very well offend someone by speaking to something that they believe very strongly. Do you think that that was something that would be helpful to that one juror that he's trying to find?
Well, it depends on who's on the jury. I mean, it depends on the state. I mean, we can stereotype things and say, well, there are fewer people here in New York that would be persuaded by a religious argument and more people in another state who might be. But look, the attorneys presumably...
Let me just stop you there, though, because the religious argument is, you could also make the argument an eye for an eye, which is also a religious argument, so that when you start getting into...
now we're splitting the Old and the New Testament.
Right, exactly.
And, so, look,
but I mean, that's a problem.
Part of me wonders if that was aimed at someone specific who answered a question in voir dire, who said, yes, I'm a churchgoer, but I think I could sit on this death penalty jury.
And I think that's probably the case. And it was talked about a little bit in the chat rooms as well, that during voir dire, they would certainly, they being the lawyers, would certainly be exploring people's religious beliefs and religious backgrounds, because some religions do not allow you to make the decision that the death penalty should be instilled upon someone. So these lawyers do have some sense of those 12 persons' beliefs. And I think you're right, Aaron. I think that perhaps there is one person that he felt may receive that call in such a way that it might save his client's life.
I would suspect that those closing arguments were aimed at specific things that were written by specific jurors in specific voir dire forms, or that were uttered during the jury selection process. Because look, at this stage, it's not about making big blanket statements, although there's some of that going on. It might just be trying to get this one to fracture off, that one to fracture off, because all they need is one to split. A hung jury becomes life in prison at this stage.
Yeah, just one person. And so you're right. I think that if I were he last night when he's preparing for this argument, I'd be going through the voir dire and looking for that one person who I might be able to tug at their heartstrings or speak to their conscience or speak to their morals. And he did talked about morals quite a bit, and to sort of counter against the morality of the whole, which seemed, as you said, pretty adamant that this was first-degree murder. They came back so quickly and so adamantly with the highest charge on every single one of these. Now, we just saw another death penalty case in Florida, the Toledo case, and in that case, 2 children were murdered. Do you think that this case, you know, it's always a different jury, different lawyers, different set of facts, but do you think that this case is more likely to result in the death penalty because of the nature of the crime and the fact that he testified?
Boy, that's a good question. I think it dials back to, look, different lawyers, different jury, different jurisdiction. The Toledo case had its own horrific elements, but in this case, I think that the defendant, And it just carries a different feel. Now,
Well,
whether it's going to flip it one way or the other is really hard for me to say. In this case, it's a younger individual, maybe a presumption that he was more impulsive. I mean, you've got an ex-boyfriend versus
right.
a husband,
Right.
but I'm struggling to say that one is either, ought to be let off the hook more than the other.
Right, and I do know, and as we both said, it depends on the jury, but I do think also the fact that they had bodies in this case, that bodies were found as opposed to in Toledo where the bodies were never found. So there's evidence of the level of horrific nature of the crimes that I think could actually, those aggravating factors could actually pull on people's emotions in a little bit more strong.
That's an excellent point. I didn't think of that. So yes, we know from the medical examiner's testimony in this case
Right.
just how much each of the victims was forced to suffer before they died. And of course, that's what the prosecution brought up during its part of this case. In the other case we covered, the Toledo case, we didn't have that
Right.
because the bodies were never found. So we don't know precisely how everyone was killed. We've got versions of it that came out of the defendant. Was he telling the truth? Was he whitewashing it? Was he covering some of it up? We don't know.
Right. It's we talk about this a little bit, but how difficult it must be for these jurors. When you get that jury notice and you're like, oh gosh, jury duty. And I know I often encourage people, please serve, because I'm starting a trial in a few weeks, and I want jurors like all of us who watch trials and want to serve and are interested in learning about whatever the case is about. But it is an endeavor. I mean, it's an endeavor just to come every day and put away your phone and pay attention from 9 to 5 and sometimes later. I know you've been here a lot later, but now in this case, to go above and beyond and to know that you hold someone's life in your hands, it is something that you cannot overstate how important it is to our system and how difficult it must be for those 12 people.
I wouldn't want to sit in those chairs. I have served on a jury at one point in my life. It was a slip and fall civil case, and it was long before I had even thought about going to law school. It was when I was fresh out of undergrad. I was I think the youngest member of the jury. And from what I recall of the process, the struggle was in applying the law to the facts, because in that jurisdiction at that time, we couldn't take the instruction as to the law back in the jury room. So we're trying to remember all of these lengthy instructions back there. And this is why so many judges say, hey, look, you've got copies of all of these things to go back and review rather than coming in and out and trying to commit it all to memory.
And it's also why so many of our cases end in mistrials, because the jurors come back for more explanation on the law. And sometimes we've seen in so many of our cases the judges won't give it or they're not able to give it. And so the fact that this jury came back so quickly certainly shows that that was not an issue for them. The legal instructions, certainly they seem to have understood them well enough. Now, it may be different in this stage.
In this case, I think the state did a good job of pointing out to the jury exactly how the law fit the facts.
Right.
And when the system is set up to provide a closing argument and then a rebuttal, it's set up in such a way that oftentimes many of the prosecutors use either the closing or the rebuttal, usually the closing itself, to actually just go methodically through the points and say, look, the judge is going to instruct you on this, so just so you know the buzzwords, the keywords, here they all are. And I think the most effective ones use charts. They use documents, they use PowerPoints and say, this is what the law says, and this is exactly how we proved every single element of it. So when you're back there, you don't have to do all the guesswork about what plugs into what else. And of course, then the only thing the jury has to do is really weigh the prosecutor's credibility.
Right. Which is why credibility of lawyers is so important in these cases.
Yeah, and you've heard me sit here and say, hey, look, I think that guy's overselling the case a little bit. And you recognize this because you're good at what you do. The key to lawyering is understanding the strength and weakness of an argument. You could, in theory, in every case, argue maybe 30 different things. Sometimes you got to choose, okay, these are my 3 best. These are moderately worthy.
Right.
So I'll throw them in, and then the other ones, I could argue them, but to what point? Would it just result in a waste of time? Would it result in confusing the issues? Would it potentially be open to an easy attack?
Right.
Because it's a weak argument. It's an argument, but it's a weak one. So a lot of what lawyers are doing are characterizing and making decisions and judgments on the strength and weakness of arguments. That's what I like about it. I think you probably like about it. In this case, though, back to the original point, I'm not sure that I would want to sit in those chairs.
Oh gosh,
Because
I know I wouldn't.
It's a horrible situation. You know, not only do they have someone sitting in front of them who's been convicted at this point, and I think beyond a reasonable doubt easily, of killing 4 people, but look, he's a young man. We know that he had a difficult upbringing. We know he witnessed abuse. We know he had abandonment many times from both his father and his mother to various degrees at points of his life. Does that mean it should get him off the hook for a death penalty decision? I'm not sure, but it's also not my decision to make. I look at these trials and say, hey, look, regardless of what the jury does, I don't think that it's wrong at the end to walk away from it and just feel bad for a number of different people.
Absolutely. And in this situation, you know, to make the decision as between life and death, I think that we have some people who are watching who feel as though the death penalty is the appropriate punishment here, and some people who do not. And I'm sure that the same holds true for the members of the jury. Do you think that we'll see longer deliberations for this stage than we did for the guilt stage?
I wondered that yesterday, and part of me wants to say yes, because it's one thing in a case like this to look and say, you know what, this guy did this, because we were saying that here early in the process. He lived there, you know, the using of the credit cards, the ordering of the pizzas, says he's not there when he really is there. It just added up to a very slam dunk case for the state. Now, the harder part is deciding whether or not the death penalty should be inflicted in this case. And look, it's hard to imagine a more horrible set of murders, though. So for all I know, they could go back there for an hour and come back and say death penalty. Or they could take 6 hours and come back and say death penalty after they really struggled with it.
Right.
We don't know. Or they could go life in prison. We just don't know.
Yeah, I mean, I think that from the defense attorney's perspective, and there are some, Skye had just mentioned that she thought it was a very good closing. I think he really tried to do everything he could to save his client's life. You know, he brought in the argument, even though the jury had already rejected it, that this was not really first degree and it wasn't premeditated and that type of thing. He even threw in the argument that he didn't, in fact, try to kill any of the other people, the people coming to get the dogs or the people delivering the pizza, as if that was some sort of mitigator. He spoke to Shakespeare, he spoke to Jesus, he spoke to morals, he spoke to religion, he spoke to the people in Adam's life who came and testified on his behalf in this stage. So really drawing upon every possible thing that would call to any one of the jurors, those close to their family, those close to their children. You know, the fact that one thing that he mentioned, Aaron, and I know, you and I sort of rotate, so you're here when I'm not, but one of the things that he mentioned is that he said you saw Adam Matos crying when they showed the video of Matos with his son Tristan in the Circle K. And at one other point he mentioned, I don't remember ever seeing Matos crying. And in fact, I thought that was something that the chat rooms had commented on. Did I miss it?
Well, there's a couple of prongs to that discussion. A, it may have happened and it wasn't on camera.
Right,
so if it happened during the trial, we just didn't see it. But I remember him getting emotional at some points during this penalty phase, not during the original trial. And that's another, just one of these spooky coincidences, or I shouldn't say coincidences, just facts. Maybe he was more emotional during the trial and the camera was just aimed on the evidence.
Right, that's one of the disadvantages of not being live in the room. You know, you just can only see so much.
Maybe he was, but I recall him being more emotional when his family was up there testifying during this penalty phase. So it raises all of these strange, bizarre questions about, okay, well, he's close with his family, but did he show any emotion or seem to care very much about the family that he killed? And a lot of people, myself included, are saying, look, he was cool as a cucumber when he was up on the witness stand talking about committing these murders.
Well, and if you're going to be cynical about it, you could certainly argue that his lawyers pointed out to him that a few tears may be helpful in the penalty phase, whereas in the guilt phase, maybe he thought that he actually had a chance of being found not guilty, and so did not feel the need to show that emotion in the same way. Because we do know, and this is something we've talked about, you know, the jury is constantly looking at the defendant. So a good lawyer will talk to their client about that and say, you know, it doesn't hurt to show emotion. It doesn't hurt to be human, especially in this situation. So Adam Matos' position towards the jury and his expectations of what the jury was thinking about him may have changed quite a bit from the time that he was up on the stand thinking he might use his charm to convince them that this was not first-degree murder, to the time when he realized that he is truly facing the death penalty here. What do you think about his decision to wear the jail clothes? I know that at one point when I wasn't here, the judge had said that was his decision. Now today, and I don't know if you had arrived yet when this happened, the defense attorney pointed out that he was wearing those clothes during his closing and said he will never get out of those clothes. He will never leave the prison. His only opportunity to leave that prison is going to be in a box. Do you think the decision to wear the jail clothes was a conscious one to draw on the sympathies of the jury?
It might have been. I mean, it was interesting to see him donning the jail uniform, so to speak, yesterday.
Yeah.
I don't know. I think that it also may play into some of what the defense said in the opening to the penalty phase, and that was similar to the closing, just saying, hey, look, as I recall the opening to the penalty phase going, the defense said something along the lines of, well, we respect your decision as to the first-degree murder counts. Well, now we're here to talk about the life that the defendant has had. It almost may have played into a strategy. Now, to hear you point it out, and now I've got my wheels turning, it may have played into a strategy to ultimately say, hey, look, we respect the finding of guilt. Now,
right.
That stage is done, we're fine with it. In other words, we're not going to keep contesting that part of it.
Right. Yeah. I mean,
interesting.
It certainly, and then sort of negated by the idea that this was not premeditated, which is what he seemed to argue. The other thing that I thought was interesting, and I think that I could argue both sides, as I often feel like I can, but the defense attorney during his closing was getting really frustrated by the slamming of the door that kept happening and sort of interrupting his closing speech. And he was also getting really frustrated at the number of objections, though most of them were sustained. So his frustration, at least according to the judge, was not necessarily well-founded. But when he got visibly frustrated at the sounds in the courtroom, that can sort of go both ways with a jury. I mean, I understand it because he's sitting there arguing for his client's life. I mean, this is truly trying to save someone's life. And so to have people, oh, it looks like we're back in the courtroom, Aaron, and we're going to hear some instructions from the judge. So we're going to take you right back live to the courtroom. Thank you so much for being with me here, Aaron.